Welcome. Welcome to today's webinar. I am Pat Parody, the Center for Constitutional Studies Executive Director, and I am pleased to be moderating today's webinar. Now, to begin, I'd like to encourage you to take note of the land that you inhabit. This webinar is coming to you from Treaty 6 territory. We honor the ancestors, traditions, and the spirit that first drew Indigenous people, the Cree, Blackfoot, Nakota Sioux, Iroquois, Dene, Saulteaux, Inuit, Métis, and then settlers to this gathering place. And we are grateful for the many benefits we have received as a result of the treaty, which was signed in 1876. We also recognize the ongoing acts of settlement and colonization that take place here, and that honoring this land and its ancestors is only a very small part, a very small step in recognizing the spirit and intent of the treaty and of our efforts towards reconciliation. Now, today's webinar, Can Women's Equality Rights Slay the Notwithstanding Dragon, presented by Professor Carrie Frock, will examine several sections of the Charter, but will focus on Section 28, which is one of the so-called interpretive provisions of the Charter, and one that has been little used and actually very little is known about it. She's going to discuss the meaning and the legislative history of Section 28, which guarantees rights equally to male and female persons. Then she will argue that properly interpreted, Section 28 may be applied to invalidate Quebec's Bill 21, and that's the bill that prohibits the wearing of religious symbols in employment in the public service in Quebec, despite the National Assembly's invocation of Section 33, the Notwithstanding Clause. In other words, she's going to describe how Section 28 can be used to override Section 33, the override clause in the Charter, which would allow courts then to strike down the law banning the wearing of religious symbols in public sector employment. It's a radical idea and one that we are anxious to hear about. Now, before I introduce our speaker, this is a reminder that the webinar is being recorded and will be available on the Center's YouTube channel. It will also be available on the front page of the Center's website, Center for Constitutional Studies website, as of this afternoon or tomorrow. And those of you who have registered should receive notification of the recording being available. Now, Professor Frock will speak for about 30 minutes, and she will then answer your questions. And we encourage you to put your questions into the Q&A section at the bottom of your screen. You can use the button to enter your questions throughout the presentation. And note that if you wish to ask your question anonymously, you have the opportunity to do so. So now I am very pleased to introduce our speaker for today's webinar, Carrie Frock, who is an associate professor in the Faculty of Law at the University of New Brunswick, as well as a Trudeau and Vanier scholar. She has taught courses at Carleton University, Queen's University, and the University of Ottawa on feminist legal theory and various aspects of public law, among others. Carrie received her PhD from Queen's University in 2016 and holds a Master of Laws from the University of Ottawa, a Bachelor of Laws from Osgoode Hall Law School, and a Bachelor of Arts from the University of Regina. Before completing her doctorate, she spent 18 years as a civil litigator in Regina, a staff lawyer for the Women's Legal Education and Action Fund, LEAF, and as a staff lawyer in the areas of law reform and equality at the Canadian Bar Association. Her research and teaching interests include women's constitutional rights, equality, social and economic rights, access to justice and the rule of law, feminist legal theory, and constitutional interpretation. Carrie is working on a book called or it may be tentatively titled, The Gendered Constitution. And her recent publications include Is Federalism a Feminist Issue? The Gender of Division of Powers Jurisprudence, in the Journal of Parliamentary and Political Law, and A Prayer for Original Meaning, a history of Section 15 and what it should mean for equality, in the National Journal of Constitutional Law. And so, without further ado, we're very, very anxious to hear from you, Professor Frock. Over to you.
Well, I also rock, but so thanks, Pat, for that introduction. I kind of feel like this is Freaky Friday because I was just listening to Pat a number of weeks ago, and she was presenting on Section 28. So here the roles are reversed. I'm just going to share my screen so that I can get into my PowerPoint here to the extent that that helps us all. There we go. So talking about the Notwithstanding Dragon, and I've talked about Section 28 a number of times, and I have to do things to kind of freshen it up and amuse myself. So I'm using the analogy of dragons today in the Notwithstanding Clause, and there's kind of a superficial analogy you can make between dragons and our Section 33, and there's a deeper meaning. So superficially, the Notwithstanding Clause, like dragons, has its own mythology that surrounds it, its own origin story, and its own mythology about its ferocity and the difficulty in defeating it. But at a deeper level, both dragons and the Notwithstanding Clause itself have a gendered implication. Dragon is a very masculine symbol of power in many cultures. And I like this quote from Dan Fisher, where he talks about the Western dragon in particular is an embodiment of man's primal desires. They were large, strong, long-lived, difficult to kill, cunning, natural masters of fire, which is man's greatest tool, and traditionally fond of capturing beautiful maidens. So the Notwithstanding Clause itself is masculine because it was literally conceived by men, as I'll talk about. It's kind of the master of the charter because it was a new powerful tool that in the hands of judges, the charter was. And obviously the Section 33, the Notwithstanding Clause, removes a number of those rights from the ability of judges to strike down laws on the basis of them. It's a strong provision covering many provisions of the Charter, Section 2, which includes our fundamental freedoms, and 7 to 15, notably including equality rights in Section 15. And it's really difficult to kill. There aren't very many in fact, no conditions in its text in terms of things that the government has to do before invoking the Notwithstanding Clause. A colleague, Jason McLean, who's here today, and I are working on an article to say that there are some procedural hurdles that government should have to go through, but those aren't in the text. Those would be doctrine. So here's my roadmap for today. I'm going to do a little bit of story time, a bit of show and tell to talk about the origins of Section 28 and the Notwithstanding Clause, Section 33. We are going to do what I call a little bit of a reality check, talk about Bill 21, the implications of Section 28 for Bill 21. And if I have time, I'll do a bit of myth slaying around the way that Section 28 operates, as well as what Section 33, the Notwithstanding Clause, does. So first, our story time. This is the text of Section 28 of the Charter. These words were very carefully chosen, so I like to start with referencing them. And they say, notwithstanding anything in this charter, notwithstanding anything, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So you'll see here that it's not a repeat of the General Equality Clause in Section 15. It doesn't talk about different identity categories like sex. It talks about people. And it really, that was intentional because it has a special role. And what Section 28 was meant to do was to root out gendered applications of the Charter and protect the rights of women and girls from being undermined or negated by other charter provisions or gendered interpretations of the charter, so gendered charter doctrine. And the story of Section 28 is rather a unique one, and I haven't been able to uncover anything like it in terms of its origins, because it was a provision that was drafted by women. These were citizens acting in a voluntary capacity. It wasn't government officials, and it was for the benefit of women. The group that was most active, in addition to National Association of Women in the Law, which I chair now, there is a group called the Ad Hoc Committee of Canadian Women on the Constitution. And they injected themselves into the constitution making process rather late in February of 1981, and lobbied politicians, worked with the government drafters, and in fact presented a draft to the Department of Justice in the beginning of March of 1981. And they were very successful in persuading politicians to entrench it with very little change to their draft wording. So it became part of the draft charter formally in April 1981, as I'll talk about many months before what we now know as the Notwithstanding Clause, Section 33, became a part of the draft charter. So this was the first Notwithstanding Clause, the original, the OG, and then there came about a second one. So despite the fact that it's been with us a very long time, and in fact, Section 28 was operative 3 years before Section 15 was, it's really underdeveloped in the case law, as Pat mentioned. And to the extent that people have heard about it, its power is rather underestimated. It's kind of like the maiden in my little analogy. So the question really is, can we tell a different story now about Section 28? So can Section 28 step to the forefront and defeat our dragon independently with no one else's help? Or shall we look at it in another gendered way as a simple damsel in distress? Maybe it can help a little bit with interpretation, but otherwise it's rather dependent and weak. And I was reminded of the story that I listened to when I was a little kid by Robert Munch called The Paper Bag Princess. He came to my elementary school and he said, yes, girls can defeat dragons. All they need is a little bit of cleverness here. And interestingly, when I looked it up again last night, I saw that it was published first in 1980, the year that the charter was first tabled in Parliament. So coincidence? I'll leave that to you. So in this slide, I'd like to talk about why Section 28. What were the reasons for putting Section 28 in the charter? And this little photograph is kind of a funny excerpt from some of the women activists where they took the picture of the Fathers of Confederation and cut out their own heads and pasted it on their bodies. So I enjoy that very much. And as I said, the draft charter was first tabled before Parliament in October 1980. And when it was, feminists were really concerned. And the reason that they were concerned is that really the drafters, politicians, didn't pay much attention to equality rights. They essentially took what was in the Canadian Bill of Rights, which wasn't particularly effective, and stuck it into the draft charter. And so feminists were really concerned that the text was not going to be sufficiently strong enough to withstand the narrow interpretations that judges imposed on equality in the Canadian Bill of Rights, or to dissuade judges that they shouldn't go the route of the US and adopt a narrow interpretation that treated sex discrimination as less serious than other forms of discrimination. And another preoccupation was Section 1, which they called the Mack Truck Clause. And the reason that they called it the Mack Truck Clause is that they thought the Section 1 justification was going to run all over women's rights. And they didn't want women's rights to be run over to satisfy or in the name of collective interests. So they fought to entrench gender equality in the strongest possible language. They went before the Joint Committee on the Constitution, which was televised, to talk about these problems. And to a great extent, they were successful. But the one thing that they weren't successful for until later in the process, as I mentioned, was getting a preeminent gender equality clause, which was Section 28. It took right up until the last moment, the third reading of the draft charter for Section 28 to make an appearance. And so at that time, again, I have to emphasize that we didn't have Section 33 then. We didn't have the Notwithstanding Clause. That was months later, November 1981. So there was still a sense that we need this protective provision to protect against any other part of the charter that might be used to undermine women's rights. But they didn't have Section 33 in mind, particularly because it didn't exist yet. And that was another fight that women had to win that I will talk about in a moment here. So there's lots of things that I could talk to you in relation to Section 28. I wrote a 476-page brick on it, but I think what I want to talk to you about today is about what this introductory clause, notwithstanding anything, what does that mean? And what does history tell us about the meaning that we should give to this clause? And secondly, I'll talk to you a little bit about the gender equality lens. And that was the idea that Section 28 is kind of this umbrella of gender equality that infuses the entire Constitution and what we can take from that. So, notwithstanding anything, sounds pretty absolute, and indeed it was meant to be absolute. It's just as absolute today in the text as it was when women were fighting for it back in 1981 and when it became entrenched and the charter was patriated in 1982. Notwithstanding anything, as I mentioned, refers to really a protective power. So Section 28 has an independent power insofar as it can block the effect of other provisions. I talked about it blocking the effect of Section 1, which is quite controversial, at least in the minds of judges. It wasn't a particularly controversial notion amongst all of the players. And as I'll argue, it can block the effect of Section 33. But Section 28 also contains the words, the rights and freedoms referred to in it. So the rights and freedoms referred to in it are guaranteed equally between male and female persons. So there is a little bit of dependency written right in the text of Section 28. It depends on other rights that are being threatened, equal rights, before it's triggered, before it comes into action. So if there's a potential threat of other provisions being interpreted or applied in a manner that would result in unequal rights, then Section 28 essentially can act as a block. So there's an interdependency, but it doesn't mean, again, that Section 28 is merely interpretive or is dependent. It does have private, or rather, it has independent power. It also has an interpretive role, but it's not only interpretive. So other things about this wording, and as I said, it was chosen very carefully and deliberately, referring to rights and freedoms in the plural. So it denotes that Section 28 was not meant to be mere emphasis in relation to the sex equality guarantee in section 15. It was to have an influence over all provisions of the charter, all rights and freedoms, all provisions like section 1, like section 33. So again, there's an interdependency in the international context. Sometimes these are called parasitic clauses. I don't like the pejorative connotation of that, but there's interdependency, but it doesn't need the operation of another right per se in order to spring into action. So by contrast, let's take a look at the other origins of section 33 here. In the 1970s, when government officials first started to muse about an entrenched Bill of Rights, around that time as well, there started to be talk about a non-obstante clause or a notwithstanding clause. We lawyers love our Latin. Essentially, non-obstante just means notwithstanding. And that was because the provincial premiers who were attempting to negotiate patriation with the federal government were very suspicious about an entrenched Bill of Rights. They didn't like the additional power that would give courts. They thought that it would undermine provincial power. Therefore, if you look at the draft, it went back and forth in terms of what rights were included. Section 15, the general equality right provision, was one that was often taken out. But as we know, there was no agreement in the 1970s over the amending formula was the big issue, but also in relation to the draft Bill of Rights. So as I mentioned, there was a draft charter that was passed by Parliament in April 1981. You might wonder, well, what happened between April 1981 and November 1981, where you had the Kitchen Accord, where the notwithstanding clause is given life? Well, what happened is the patriation reference before the Supreme Court, and the reason that we have that decision is that the federal government started to get rather perturbed by all of the haranguing and back and forth with the provinces over the amending formula and other parts. They couldn't get an agreement, so they said, fine, perhaps we'll just go to England ourselves unilaterally and get this patriated ourselves. Provincial governments didn't like that. They got some decisions from their appellate courts, which found their way to the Supreme Court. And the Supreme Court said there had to be substantial agreement with the provinces as a matter of a constitutional convention before the federal government could take a draft constitution to England to be patriated by their parliament. So there is a number of changes as a result of a constitutional conference that occurred in November 1981 to get the provinces to agree to a draft charter. And Section 33 was a critical element of that. And it was drafted by a few good men. You can see them there, Chrétien Murtry and Roy Romano from my home province of Saskatchewan. They came up with the notwithstanding clause that we see today, although, as I said, it was in the works for a number of years. And they specified what rights were going to be subject to the notwithstanding clause. For instance, they knew that Trudeau would never agree to have language rights subject to it, so those weren't included. But they completely forgot about Section 28. No girls in the room. I think I counted one woman that was in the entire First Ministers Conference. No women were there in the kitchen, and that's the kitchen of the conference center where the conference was held. No women in the kitchen when the Section 33 notwithstanding clause was being baked. So there was a back and forth between provincial bureaucrats and the feds as to whether Section 28 should be included in the notwithstanding clause. And ultimately, even though they forgot about it, it was like, let's just stick it in. It makes sense. And women across the country of Canada were furious. So there was a massive lobbying campaign. Trudeau, who was no fan of the notwithstanding clause to begin with, said, fine, if you want to take Section 28 out, then you'll have to get the unanimous agreement of all the provincial premiers, which they managed to do. And that's why we have the text of Section 28 today. But the text that was proposed when Section 28 was going to be made subject to the notwithstanding clause is rather interesting. Section 28 would have read notwithstanding anything except Section 33. And Section 33 would have been amended to end with notwithstanding these rights, sections 2 and 7 to 15, or Section 28 of this charter in its application to discrimination based on sex referred to in Section 15. So pretty specific understanding that sex discrimination, for instance, wouldn't be subject to the notwithstanding clause if Section 28 went in as is. So after the Section 28 was removed from 33, Judy Arola, who was the Minister for the Status of Women, said that it would bolster Section 15 so judges will know that when we say no discrimination on the basis of sex, we mean never. So what this shows us then is that if Section 33 applies in a way that results in an unequal enjoyment of rights as between men and women, there's a violation of Section 28, and 33 doesn't apply to 28. So a law could potentially be struck down for violation of Section 28. As I'll talk about in Bill 21, this becomes really concrete. And although this hasn't been tested, it was pretty crystal clear from the history that sex discrimination was under Section 15 was to be excluded if it results in unequal rights, which is 100% of the time when you're dealing with sex discrimination against women. So that leads me to Bill 21. And Bill 21 is known as the Religious Symbols Bill. I don't know what the long title of it, it's not a bill anymore, it's a law, but it's informally still known as Bill 21. And there's two provisions that really have large implications for women's equality. There's a prohibition against receiving or providing government services with a covered face. Essentially, that has been known as the Niqab Ban. The Niqab being a Muslim garment that Muslim women wear that only reveals the eyes in the face. And it also forbids the wearing of religious symbols for employees of the state deemed to be in positions of authority. So that includes police officers, that includes teachers. And there was a rather omnibus invocation of Section 33. So all the rights that could potentially be subject to the notwithstanding clause, sections 2 and 7 to 15, they're all overridden, for lack of a better word. So what does this mean? And they were over also in Section 33 was also invoked preemptively. So no court had decided that Bill 21 violated the charter. It's pretty obvious that it does. It was, but nevertheless, it came before the Quebec Superior Court. back in April 2021. So remarkably, April 2021, the same time that Section 28 got entrenched some odd 40 years prior. And the trial judge made some pretty important factual findings. He said that it was obvious that Bill 21 targeted Muslim women and that it disproportionately impacted them. He found as a fact that they are the vast majority, if not all of those affected, that the religious symbol ban was derived from concern over religious symbols worn by Muslim women in particular, and that Muslim women were particularly vulnerable because those who wore the hijab, which is the Muslim hair covering, it covers the head except for the face, were 100% of those whose job applications were closed, meaning refused or returned as a result of Bill 21. So school board would get a job application. If they caught wind that a woman was wearing a hijab, they would say, no, can't entertain your job application. Those to whom that happened, 100% of them Muslim women wearing the hijab. So despite the fact that the trial judge made some pretty significant factual findings, he misinterpreted, in my view, both Section 28 and Section 33, and essentially found that Section 28 couldn't operate to invalidate the law. And I say this is wrong because, first of all, by invoking the Notwithstanding clause over freedom of religion in Section 2A, this primarily affects the religious freedom of Muslim women. And so what this means is that they have unequal freedom of religion compared to men who don't feel this disproportionate impact. I also say that Bill 21 discriminates against them on the basis of sex, contrary to Section 15 of the Charter, because it communicates discriminatory messages about Muslim women, that their dress is a way of rejecting the social values of Quebec, that they are entirely oppressed by their culture or their family. And it also has the effect of widening social gaps between them and other Quebecers, where they're already socially and economically disadvantaged in terms of integrating because of gendered Islamophobia. So a case of sex discrimination obviously means that men and women are enjoying unequal rights. And so Section 33 being invoked and covering Section 15, it potentially would strip women of having the benefit of equal rights. So in itself, that constitutes a violation of Section 28. So that's the general argument as to how Section 28 and its violation would apply, and a violation of the Charter, obviously pursuant to Section 52, means that a court could invalidate the law because it's inconsistent with the Charter. So the trial judge agreed with me and other people, didn't cite me, sadly, that Section 28 is more than interpretive. But because he misinterpreted what Section 33 actually does, that led him to another misinterpretation as to how Section 28 and 33 interact. So that's the reason he found that Section 28 couldn't invalidate the law despite its perpetuation of inequality. He did make a more minor ruling that the minority language school boards, the English Montreal School Board was one of the parties, didn't have to follow Bill 21 because it interfered with the management of these school boards and therefore violated linguistic rights under the charter, which, as I mentioned, are not subject to Section 33. So this might be Section 28's time to shine, because that trial decision is now at the Quebec Court of Appeal. But in my view, it's obvious that it will need to continue to go up and likely would be heard by the Supreme Court. Now, I don't want to talk for much more because I want to leave time for questions, but I will tell you a little bit about some of the arguments that have been made to try to push back against the interpretation of Section 28 that myself and others have made. Three arguments are the general ones that I've heard. It don't mean a thing, disempowering, it's merely interpretive. The surely you can't be serious argument. Section 28 might do all sorts of crazy things if it did what the text says it does. And freedom's just another word for nothing left to lose, and what I call the net rights argument. So again, I'm not going to go into detail. You can ask me some more questions about it, but the idea that Section 28 is merely interpretive took hold after some very bad jurisprudence. But I don't really understand that argument if we're looking at the text as our guiding light, because it was clear that when the drafters and politicians wanted to reference interpretive provisions, as they did with the Section 27 notwithstanding clause, they knew how to do that. They used the word interpretation. It's true that obviously Section 27 comes right before 28. And some people have made a lot of hay about that. But if you review the history, this was more a quirk of history and idiosyncrasy rather than any kind of real deliberate thinking that these two provisions are the same. With surely you can't be serious argument that crazy things would happen if Section 28 was truly notwithstanding anything. Alan Blakeney, for example, trotted out the example of, well, little old ladies will be forced to live with men because apparently the Saskatchewan Human Rights Code said that if you're renting out rooms in your house, you can discriminate on the basis of sex. So if you're a woman, you can say, well, I don't want men to be sleeping in the bedroom next to me, for example. And there was also a question about whether affirmative action for women would be allowed if you had a gender equality clause, an equal rights clause like Section 28. Those were both arguments that were made at the time by Blakeney. The other politicians didn't take them particularly seriously. Women advocates smacked them down by saying, well, we have Section 15.2 that protects affirmative action programs. And furthermore, Section 28 doesn't guarantee absolute no differences between the sexes whatsoever in legislation. That wasn't its purpose. Both Section 15 and Section 28 have substantive equality at its core, which is about equality in result. Interestingly, some case law also referred to a public decency argument, why Section 28 can't mean what it says it does. That one case was about a talented hockey player that wanted to play on the men's hockey team and invoked Section 28. The court said, no, because that would be a violation of public decency. The net rights argument is one that is a little more technical, but essentially it means that, well, Section 28 applies after the invocation of the notwithstanding clause. So these rights are neutralized, sections 2 to 7 to 15, So there are no rights left to equalize as between men and women after Section 33 overrides them. So Section 28 applies to the remnants of rights that are left after Section 33's effect. And so this really, accepting this argument means that you have to accept how Section 33 operates and look at it as overriding or neutralizing rights versus, as some have argued, simply allowed legislation to operate notwithstanding rights. And the word operate in Section 33 ought to be given a particular meaning. And it could have said that a law shall not be consistent with the charter or shall be valid, notwithstanding sections 2 and 7 to 15, but it said not operate. So others have argued that these rights still exist. The fact that Section 33 has been invoked doesn't mean that rights go away, that they magically disappear. They still have full power vis-a-vis the law. It simply means that a judge cannot invalidate a law based on them. So if the underlying rights still exist, then the protective function of Section 28 can operate to protect them from the application of the notwithstanding clause, where that results in unequal rights. So I think I'll leave it there. I'll just ask you, and I'll deputize you to be good constitutional ambassadors. If you agree with my argument on Section 28, go forth, correct any misunderstandings, advocate for the relevance of Section 28. And going back to the paper bag princess, the princess in the end outwits the dragon by playing on his arrogance, causing him to expend all his energy in answering his challenges so that she can escape. So we need to similarly, cleverly, deliberately ignore the smoke, take out the fire from the notwithstanding clause, so that when it comes time to challenge the destruction of women's rights, all of its weaknesses are exposed. So thank you very much. I look forward to talking to you a bit more with your questions.
Thank you very, very much, Carrie. That was a great talk. Very, you really were able to explain a whole lot of what Section 28 is about, its history and all of that. That makes such a difference to understanding how it can function at this point in our history. We have a question here from Professor Charisma Mathen, and she agrees. Carrie, great talk. You suggest that the correct outcome would be to strike down Bill 21, Loi 21. Is that because the law at its core is directed at women, or would that always be the correct outcome? That is, would there be room for reading down instead?
Yeah, well, thanks, Charisma. I don't think that Section 28 itself dictates any particular remedy. But if you look at the two provisions that I talked about, I don't think that there's any way of reading them down in particular that wouldn't have that impact on Muslim women, because it was meant to target them. That was the raison d'etre of those provisions. So if you have a provision whose very purpose is to violate charter rights, essentially, I don't know how you can preserve them. I don't know if there's anything constitutional that's left of them after you have a court making that kind of declaration. But essentially, if you agree with what I'm saying and you find a charter violation, Section 33 would essentially be irrelevant at that point, and the courts could do their usual thing in relation to Section 52 and the remedies that the court has found flow from there.
So what you're saying is that Section 28 will ultimately only apply to other sections of the Charter, as the text states. And once you override the override, you're back to a specific Charter challenge, as you would be in the
Kind
normal
of,
course of events without the
right.
notwithstanding.
Yeah, it's a defensive or a protective mechanism, essentially, in that respect.
Okay, thank you. We have another question here. Section 28 does not include a subsection similar to subsection 2 of section 15, which allows affirmative action programs. So why do you say that section 28 includes substantive equality? If you are correct that section 28 is as absolute as the text implies, that the guarantee of equality between male and female persons supersedes section 15.2, does it not? Could you perhaps just clarify why you think section 28 allows women to discriminate to prevent male roommates, for example? Wouldn't the absoluteness of section 28 preclude that kind of discrimination if section 15 sub 2 were nullified by section 33?
Well, the first thing is I think you have to make a distinction between making a distinction and discrimination. And that's pretty conventional interpretation of the word equality by our courts. The courts have always interpreted equality to mean substantive equality. Even the Supreme Court says this goes right back to the first equality case of Andrews. So in that case, the court was careful, as it's been, to say that section equality doesn't outlaw any distinction, because that's what laws are about, is making distinctions. We tax rich people and make them pay more tax, allegedly, than poor people. That's a distinction. I don't think it's a discriminatory distinction. And so that language of equality is the same whether it's section 15 or 28. And if you look at the reason why it was drafted and what it was meant to mean, there wasn't any kind of different or special meaning that was given to equality in section 28 vis-a-vis section 15, and it makes sense in the same document that you're going to interpret them similarly. So not just me, but other people like Beverly Baines has said that equality means equality no matter if it's in section 15 or 28. But you're picking up on something that is absolutely important, that early on, judges made the mistake of saying that's what section 28 is. It's an absolutist kind of provision. And they said that if it's absolutist, it must mean formal equality. So any distinction in the law, any distinction whatsoever, is going to violate section 28 if the distinction is on the basis of sex. So I think that if you're conducting a principled interpretation of section 28, we do have section 15.2. And section 15.2 was there almost from the very beginning. So section 28 and 15.2 are in dialogue. And section 15.2 says that absolute equality of treatment isn't required. The ad hoc women that were advocating for section 28 said similarly. Therefore, I think it's a misreading to say that there's some sort of conflict between 15.2 and 28. If you look at the text and history, that goes away. And Justice Blanchard, the trial judge on the Bill 21 case, also made that mistake.
Okay, thank you. Yeah, because putting it as they're in dialogue is an interesting way to think about it, which is going forward. I'm just wondering, Carrie, in terms of process, when this goes to the courts, do you have an idea as to what sort of, if I can call it a test process, the court will have to engage in when section 28 is invoked? I'm just thinking about, is the first step going to have to be to look at, in this case, section 33, and to show unequivocally, I suppose, that the invocation of section 33 is absolutely discriminatory when it comes to women?
Well, The trial judge made a number of factual findings that will be pretty difficult to overturn. And that's essentially what he found, is that the violation of freedom of religion has had a disproportionate impact on women. And as the most recent equality case Fraser says, you don't have to show that there's discrimination or inequality for all women. If you show that there's an inequality in relation to a particular group of women, that's a distinction based on sex. That's unequal rights. So whether you're talking about the general equality right under Section 15, or you're talking about a violation of freedom of religion that has a disproportionate impact on women, Section 28 regards those similarly. They're both covered by 28.
I found it interesting when you were talking about the original way in which Section 28 was going to be framed and how it very specifically laid out sections, or Section 33 as well. I'm just wondering, in terms of, oh, I just lost my train of thought. I was just going to ask a little bit more, I guess, really about how you think the court's going to proceed in terms of the Hack case. And do you see the court making some strong statements in the Hack case around the use of Section 33? I guess one of the questions I've got is, do you have any comments on how you think Section 33 should be used? Some have said, for example, it ought not to be used preemptively in the way that it has been used with Bill 21, and blanket provisions. Things should be argued in the court, in Parliament and legislatures, etc. So, do you have any particular views on that?
Yeah. So there's a couple of things, just in terms of the history of the various textual changes that were made to 28 and 33 and then taken out again. I think a principled use of history has to make some sense of this. Some people have suggested, well, the drafters and ratifiers just didn't know what they were talking about. They thought that Section 28 would have this effect to block the operation of 33 in relation to sex discrimination and other unequal rights, but they were just, all messed up and they didn't know what really, was happening. If you have to give some credit to the people that are drafting these things. These were careful people. Lots of them were legally trained. So to simply completely discount that history and those careful textual changes that would have been made, I think is a big mistake. The text that we're left with is obvious, the text that we're interpreting, but the court has always looked at these kinds of changes in terms of what was left out. The case of Prosper concerning duty counsel and the right to legal aid is one I'm thinking of particularly. So what is the reason that we would discount that history here, except for the fact that we don't take Section 28 seriously, which is a gendered position, I think. In terms of how Section 33 ought to operate, again, that's something, an argument I'm working on with a colleague. But what we've said is that it's time to refine the Ford case, that given the change in Canada's political and constitutional culture, where the notwithstanding clause is not the nuclear option anymore, it's the option to consider as a matter of course if you don't like the charter, then there ought to be a change to the doctrine in terms of when a legislature is entitled to invoke the notwithstanding clause. And in particular, we see you can't just slip it into a piece of legislation and call that public notice. The entire charter is based upon the values of a free and democratic society. So in this year of 2022, what this ought to mean with so much information overload, that you actually draw the public's attention to it. You have a deliberative process where you have a public consultation, and you tell the public what you want to do, how it potentially violates rights. and have a public debate about whether that's appropriate or not. Whether it's could be used preemptively, that was something that was absolutely outside the realm of how the framers and ratifiers thought it would be used. And it really doesn't make sense if you look at Section 33 as a key element to the charter rather than something foreign to it. It was brought about with the idea that courts are not these oracles from on high that always get things right. There's a legitimate role for both the people and for the executive and parliaments and legislatures to do their own constitutional interpretation. So sometimes judges might get it wrong. And that's something that Alan Blakeney in particular was concerned about, that you were going to see something like you had in the US, where in Lochner and cases like that, the US Supreme Court was invalidating all of this progressive legislation on the basis of the so-called liberty of contract. So that was the purpose of it. So if you had a court striking down progressive legislation that was entirely consistent with our democracy and our welfare state, there could be a second look by Parliament. It wasn't meant as something where people could thumb their nose at the Charter and use the notwithstanding clause essentially as a way to show contempt for it.
Thank you. We have, I think, time for one more question, Carrie, and that is, to date, legal scholars have questioned the usefulness of Section 28. Why has it not been used in any landmark gender equality cases thus far?
Well, that's a brilliant question, and it's particularly brilliant because it comes from my mom.
I didn't want to say, but
why has it not been used? There's a variety of reasons for it. I think that, for one thing, early on in the Charter's history, there was a massive, massive onslaught of litigation, and you'd know this, Pat, from being involved with LEAF, a lot of litigation brought by men. And I don't think that that was something that was particularly anticipated. It was things like men challenging social assistance provisions for single moms, challenging custody and support provisions on the basis that they thought the judge was discriminating against them. And even more seriously, challenging provisions that were meant to protect girls from sexual exploitation by men, and it was a gendered criminal code provision. So those were the initial targets of Section 28, and 28 got a bad rap because some male judges used that kind of absolutist notion of equality to strike down those protections for women. So for a while, even women's groups, I think, were a bit hands-off about 28 because it was used so badly. And I think it's time to reconsider that history and take another look at it. Just because a provision was once interpreted badly, it doesn't mean that that's the interpretation that has to hang around for all time.
okay, thank you very much. That was a lovely way to end, and especially from a question from your mother.
It was a good one.
It was a good one. Good to hear. Well, Carrie, we're at the end of our hour, and I must say it's been a very, very interesting hour. And I think some of us will never lose the visual of the Section 33 notwithstanding clause being this fire-breathing, male-constructed dragon that Section 28 is about to take the poof out of, perhaps. But anyway, it's a wonderful visual. So thank you for the work that you did in preparing your presentation and for really explaining to us clearly what the history of Section 28 was, how well constructed and well thought out it was when it came into force and effect as in terms of being part of the Charter, and then how the notwithstanding clause came so much later. It was a really interesting presentation. So thank you very much. And we're all waiting with bated breath now to see what happens with this hack case and the Bill 21, because that will obviously be very, very helpful in terms of what happens judicially speaking anyway, from a jurisprudence perspective to Section 28. So thank you very, very much for your
Thanks for
presentation.
having me, and thanks for everyone's thoughtful questions. It was really a pleasure.
Yes, thank you. And so I also just want to remind people that the webinar has been recorded. It will be available on our website, the Center for Constitutional Studies website, as well as our YouTube channel. And you will be receiving a little survey. It's short, sweet, and it certainly helps us out if you can fill out that survey. We really appreciate your feedback. I'd also like to thank Alina Rietsma, who is our Public Legal Education Coordinator, for her work in preparing the session and running it in the background, along with Zara Ahmed, our administrator. So thank you both. And thank you to the audience members again for your questions and for your interest. So with that, I will close and thank you all very, very much.